Welcome back to channel Enviro Annotations. Amidst reports of European farmers expressing their discontent through road blockades, tire fires, and manure dumping, a unique narrative unfolds. In the province of Asturias, Spain, farmers find themselves entangled in a struggle with authorities, not over protests, but over the traditional practice of burning scrub. Authorities, citing the impact of climate change-driven warmer temperatures, caution against potential tinderbox conditions. Meanwhile, India's farmer protest gradually recedes from the headlines. However, this news report sheds light on a farmer story that stands apart, offering a different perspective on agricultural challenges. On the 4th March 2024, the National Green Tribunal Western Zone Bench issued a judgment following its reservation on 30th January 2024. The case revolves around the dispute between Kushabapu Ranganath Pawar and Dada Saheb Kushabapu Pawar against Padma Shri Dr. Vital Rao V.K. Patil Sahakari Shakkar Karkhana, a sugar mill, and the Maharashtra State Pollution Control Board, Maharashtra Pollution Control Board, MPCB. The crux of the matter lies in the original application number 143 of 2017 Western Zone Bench, where the applicants sought the intervention of the MPCB to investigate and report on the polluting activities of a sugar mill. Their plea extended to the necessary actions, including directives to shut down the sugar factory and restore the land to its original state. The applicants, engaged in pomegranate farming since 2009-10, underline the substantial income generated from their 400 pomegranate tree farm. Despite flourishing for 18 consecutive years and yielding substantial earnings, their agricultural enterprise faced a severe setback in April 2014. Allegedly, the Padma Shri Dr. Vital Rao V.K. Patil Sahakari Shakkar Karkhana, rather let me quote it as a sugar mill or maybe distillery, discharged 50 to 60 tankers of spent wash onto adjacent agricultural land, leading to the gradual demise of pomegranate trees and extensive damage to their farm. The industry's historical timeline reveals the establishment of 15 KLPD kiloliter per day distillery in 1970, later expanded to 32 KLPD in 1975, and subsequent addition of 60 KLPD distillery in 2002. The cumulative consent granted for both units totaled 92 KLPD kiloliter per day. Legal proceedings bring to the light the adverse impacts of the sugar mill's activities on the agricultural livelihoods. The discharge of spent wash, a byproduct of sugar production, led to severe consequences for a pomegranate farm. The applicants argue that the spent wash contaminated the soil, causing irreparable damage to the pomegranate trees and rendering the land uncultivable. Despite filing complaints with the Maharashtra Pollution Control Board and the Sugar Commissioner, the farmers contend that the response was insufficient. Consequently, the legal battle seeks to address the environmental crisis caused by the sugar mill's alleged pollution, advocating for accountability and potential closure of the sugar factory. The legal documentation unveils the challenges faced by the farmers in establishing the link between industrial discharge and the harm inflicted on their farm. Discrepancies in statements from the sugar mill and conflicting reports from the authorities contribute a complex narrative. The applicants allege intentional misinformation, political influence, and corporate power hindering meaningful action against the industry. Disheartened by the obstacles encountered in seeking justice, the farmers turned to the tribunal, urging the Maharashtra Pollution Control Board to submit a comprehensive report to the sugar mill's polluting activities. Their demands include the potential closure of the sugar factory and restoration of the land to its original condition. This legal battle underscores the vulnerability of farmers' livelihoods to the industrial activities, prompting broader questions about the environmental accountability and a delicate balance between industrial development and agricultural sustainability in the region. The case's outcomes could establish crucial precedents for navigating the intricate interplay between industry, agriculture, and environmental protection. However, the Central Pollution Control Board's perspective on spent waste reveals higher values of nutrients, NPK, and salts like sodium, calcium, magnesium chloride, and sulfate in the contaminating soil matrix. However, these parameters only indicated contamination such as sodium, potassium, nitrogen, and C/N ratio and did not signal soil quality degradation resulting from spent waste discharge. Then a reference sample at a 100-meter distance from the complainant's plots remained unaffected by distillery effluent, resembling background samples. It is inferred that the alleged uncontrolled spent waste discharge had no impact on the land, and there was no discernible adverse impact in soil quality, and the applicants claim that results might have normalized by sheer efflux of time. The NGT bench of Justice Dinesh Kumar Singh, judicial member, and Dr. Vijay Kulkarni, expert member, noted a lack of conclusive proof that the applicants suffered losses amounting to 6 to 7 crores rupees. The amount assessed by the applicants was deemed arbitrary by the NGT, which declined to accept it as a compensation. However, during the process of legal fight, the applicant had revealed that there were some deaths of workmen who were working in the factory, in the sugar factory. Now, industry filed objections were considered immaterial as the NGT had already given its findings. The main emphasis on the objection lay on the legal point on compensation should be awarded to the injured persons and dependents under the Workmen Compensation Act 1923. The NGT, referencing the case of MC Mehta versus Union of India and Orders 1987 1 SCC 395, held that enterprises engaged in hazardous activities owe an absolute duty to ensure no harm results to anyone. Strict liability is imposed and compensation must be correlated to the enterprise's magnitude and capacity. The NGT also disagreed with the industry's argument that Workmen Compensation Act 1923 should cover compensation to dependents or injured persons in this case. Instead, the NGT opted to follow the law laid down by the Supreme Court, citing various judgments including Sarla Verma and Others versus Delhi Transport Corporation and another. The NGT approved the Joint Committee's calculation and additional compensation to be paid to the dependents of the deceased persons based on the Supreme Court judgments. The NGT found no errors in the calculation and agreed with the compensation and treatment provided to the injured persons by the industry. In the light of the Joint Committee report, the NGT concluded the application directing the industry to pay the balance amount to legal heirs, dependents of the deceased persons. The MPCB was tasked with ensuring proper environmental measures, including storage provisions and dismantling unlined lagoons of the factory. The Director of Industrial Safety and Health, Ahmednagar, was instructed to enforce measures under the Factories Act 1948, Maharashtra Factory Act 1963, and MSIHC Rules 1989. The NGT endorsed the Joint Committee's recommendation for compensation to grievously injured and mildly injured persons, seeking a compliance report from relevant authorities within 4 months from the date of judgment upload. Also, visit our website enviroannotations.com, and we also have another website, enviroannotations.substack.com. I'm sharing a link down below in the description. You will get a number of articles and coverage on NGT and EIA and various other environmental issues. Thank you very much for listening to this comprehensive news report. Stay tuned for more updates on legal and environmental developments.